we'll get to them at the end. Also, just bear in mind, you know, this is more educational rather than legal advice, so just be aware of that also. I suppose, yeah, the QS series, there's a couple of other webinars there. Look, they're all available on our YouTube channel if you want to check those out. Yeah, interaction, variations, loss and expense, payment, the classics. So yeah, all good stuff. There's been some very good feedback on a lot of it. So yeah, do check it out if you get the chance. Right, so we're going to move on to the agenda today. So look, we're going to have a brief introduction into smash and grab adjudications. I mean, a term of art in the adjudication world. I just want to make sure everybody understands it, which will lead us nicely into the position on what we call true value adjudications. Then we look at insolvency and adjudication. So some really important case law that has emerged of late, just to give you an idea as to the current position in relation to adjudication for parties that have become insolvent. Before finally we'll wrap up with a very interesting case lately, and it's just a good reminder in relation to the formalities that coexist or that are very much part of the process of the adjudication process. Okay, so yeah, the first place to start, I guess, just smash and grab adjudication. Just a little recap in relation to, you know, what is it? So in essence, a claim is made by a contractor who acts on an employer's failure to issue a valid pay less notice or payment notice by claiming payment of sums stated in the interim application for payment with no regard to the employer's assessment of the validity of such claims. Where a project has regular interim payments built in, the risk is somewhat lessened by the employer's ability to undo the effects of any unjust claim in the next interim payment. For this reason, contractors have become more likely to pursue this style of claim in respect of the final account payments, where the employer's opportunity to undo the claim by the final account may take some months. So that gives you an idea, you know, of what the smash and grab claim is. Basically, it's a failure to issue a valid payment and/or pay less notice in line with the, you know, with the dates stipulated either in the contract or the regime under the scheme. So with that in mind, you can see that this is being pursued largely at final account, because on an interim payment it can just be corrected in the following interim payment. So it was a good tactic to have if final account is coming up, and that's what happened in the case of Grove versus S&T back in 2018. So brief background here is that Grove contracted with S&T to design and build a hotel at Heathrow. S&T commenced the works in March 2015. There had been 3 adjudications between the parties, and Grove anticipated an adverse result in the 3rd adjudication, and they commenced their own CPR Part 8 proceedings. So the legal background, the issues, I mean, it's a very interesting case if you get a chance to read it, and there is more going on in it than the true value position, but that's what we're focusing on today. The other issues were related to the validity of a pay less notice, and also were Grove's liquidated damages notices properly issued. But today we're going to focus on the true value. So you can see here what we're saying is that the conclusions reached on this issue will be of most interest to the construction industry and represent a change of approach from the previous authorities. Coulson was clear that an employer can commence a 2nd adjudication to seek the true value of the sum due where it has failed to serve an effective payment notice and/or pay less notice to the contractor's application. Now, he gave 6 reasons for doing this. I mean, the most important one is the final point here. What he said was the judgment represents a significant change in the TCC's approach. Coulson endeavoured to bring clarity of potential issues raised by earlier cases on smash and grab style adjudications and distinctions between interim and final account payments. The comments of the judge have the potential to reduce the impact of contractors' claims for payment on the basis of a failure to serve a pay less or payment notice, now that there is authority in support of the employer's ability to quickly bring a second adjudication for the true value of the same application. And the key point here is that in order to commence that second adjudication after the smash and grab, the second adjudication being in relation to what the true value of the account is, the point is that the paying party has to pay the sum stated as due and then re-adjudicate on the actual sum due. The sum due being the actual amount or the true value in this case. So please bear that in mind. I mean, it's a very important point to remember. The courts are saying that you can re-adjudicate if you wish, but you have to pay. The paying party has to pay the amount stated in the original smash and grab adjudication. It's still a very common misconception we come across. Parties commence the second adjudication, can do it quite quickly in order to trump any adverse finding in the smash and grab, but that won't trump the original smash and grab decision. So you've got to bear in mind that if you are re-adjudicating, pay the sum stated as due, and then re-adjudicate on the sum due. Okay, so I mean, this was reinforced in the case in the middle part of this year. It was Broseley London versus Prime Asset Management. Now, again, so the question here was, can an employer start a true value adjudication without first paying the notified sum? And the court confirmed that to allow this would be a remarkable intrusion into the principle established in Grove versus S&T, and the party could not commence a true value adjudication without having paid the notified sum. This would permit the adjudication system to trump the prompt payments regime, which should not be allowed to happen. And finally concluded that it was open to commence litigation proceedings if it wished. So you can see what the court was doing in Broseley. I mean, it was effectively answering pretty much the same question as Grove versus S&T, and versus S&T saying that you couldn't commence the true value adjudication without having paid the notified sum. So again, it's just reinforcing that point. It has to be paid before the second adjudication can happen. But what it finished, the final line there is of importance, as we'll see in our following case, because it said that it was open, parties are open to commence litigation proceedings if it wished. Somewhat maybe suggesting that rather than paying the sum stated as due and then re-adjudicating, perhaps suggesting that the party could go and commence litigation proceedings if it wished. I mean, that option is always available. I mean, as we all know, adjudication is on an interim basis and can be overturned in litigation proceedings at a later date. But a key point is that he's saying that you can commence litigation proceedings if the party so wished, which is interesting and leads us into our following case, which is Q Holdings versus Donald Insall Associates. So Donald Insall Associates were an architect. They carried out various services for Q Holdings. Now there was an adjudication, and Donald Insall Associates had obtained a decision and enforcement in its favor. Now Q continued not to pay, and they tried to commence their own litigation proceedings against Donald Insall. And that is the link between that and the Broseley case. Donald Insall applied to strike out the proceedings on the basis that Q continued not to pay the amounts that were obtained in a decision and the subsequent enforcement. Justice O'Farrell concluded here that to allow the commencement of the Q proceedings was in flagrant disregard of the pay now, argue later regime under the Housing Grants and Construction Regeneration Act, which amounts to unreasonable and oppressive behaviour. So the so finally the claim was not struck out, but Q had to pay the sums owed to Donald Insall Associates immediately before proceeding any further. So what this is saying is that, you know, if parties don't want to re-adjudicate under their, you know, their true value, on a true value basis, and they wish to commence litigation proceedings, what the courts are now saying is that the litigation proceedings are likely to be stayed if the sums stated as due has not been paid. So again, it's just reinforcing that point through this train of this trail of case law, that is the current position as the court sees it. So very, very important points. You know, if you are in that position, you know, if you are in you know, thinking about adjudication or you know, deciding what route to take, it's a very important point to remember that if you wish to re-adjudicate or you wish to commence subsequent litigation proceedings, that the amount stated as due have to be paid. And so that's pretty much it in true value section, guys. We're now going to move on to some recent develops in the area of insolvency and adjudication. Okay, so interesting case here. It came from the Supreme Court. This year was Bresco versus Lonsdale. Now, so the legal background here, what the court had to decide, what the Supreme Court had to decide was what is the relationship between A, the adjudication regime for building disputes, and B, a rule of insolvency law called insolvency set-off. Adjudication, as we know, had introduced the principle of pay now, argue later, again, as we covered earlier. Whereas insolvency set-off deals with the liquidator calculating net amounts due after setting off other amounts. So you can see there is two different principles associated with these two grounds. I mean, adjudication wants a pay now. That's the reason why, you know, that's largely the reason why we have adjudication. But how does that compare, or how compatible is that with the rule of insolvency set-off, where a liquidator is trying to establish, you know, the correct amount that are being owed? So, very interesting case, you know, in the world of insolvency, which will, you know, some case background is here. So Bresco and Lonsdale, they were both electrical contractors. In 2014, Lonsdale engaged Bresco as their subcontractor. In 2016, Bresco entered into insolvent liquidation. And both parties at that time had debts against each other. Lonsdale alleged that Bresco owed them $325,000 for leaving site. And Bresco alleged that Lonsdale had unpaid works plus damages, which totaled $219,000. So Bresco's liquidators decided to pursue the $219,000 through the adjudication process. However, Lonsdale objected on two grounds. The first being jurisdiction. So Lonsdale's position was that the set-off meant that there was no dispute, so there was no jurisdiction. The no dispute being that the sums owed to Lonsdale were greater than Bresco's, and as a result, Bresco's claim fell away. The second point was it was a futile exercise, because the liquidator calculated the net balance, so the adjudication was pointless. I mean, we're saying that the liquidator can calculate the balance on the basis of the sums above. So what was the point in going to adjudication? So those 2 points were considered, and it, you know, this really developed through it started out in the TCC, who accepted that both of Lonsdale's points and granted an injunction to stop the adjudication. So the TCC agreeing with Lonsdale. The Court of Appeal rejected Lonsdale's jurisdiction points, but upheld the exercise of futility, so the injunction remained in place. Now, this was appealed to the Supreme Court, who considered that Bresco's appeal on both grounds and Lonsdale's cross appeal on the jurisdiction points. So the outcome was on the 17th of June this year, the Supreme Court unanimously allowed Bresco's appeal and dismissed Lonsdale's cross appeal, meaning the adjudication can proceed for the following reasons. First point, the jurisdiction points. So the Supreme Court decided that the claims do not automatically melt away. Rather, they retain their own separate identity. Both claims being, Bresco seeking the 219,000, Lonsdale seeking the 325,000. Despite insolvency set-off, Bresco could still bring court proceedings to determine its claim value and even pursue arbitration or adjudication as it so wished. And the court decided that it follows that it can refer these claims to adjudication. Adjudication is they thought was a perfectly reasonable way to reach a resolution on these points. The second point was related to futility. Now, the Supreme Court rejected that there was an incompatibility between adjudication and insolvency set-off as upheld by the Court of Appeal. Bresco had a statutory and contractual right to adjudication, and it is inappropriate for the court to interfere with the exercise of that statutory and contractual right. Maintaining cash flow is not the only purpose of adjudication under the Construction Act. Adjudication was designed to be a method of alternative in its own right. And in reality, most decisions of an adjudicator are never challenged in court, and they lead to a speedy, cost-effective, and final resolution of the dispute. So final point is here, an adjudication will be a simple, proportionate method for Bresco's liquidators to determine the net balance. It is possible that the courts will not grant summary enforcement of the adjudicator's decision due to the insolvency process, but that does not deprive the adjudication of its potential usefulness for the liquidators. So you can see that, I mean, the Supreme Court is basically, supporting adjudication as a means to resolve construction disputes. It's saying that, it's not going to prevent liquidators from relying on it as well. It's available to everyone. It's available to most parties, either through their contract, either through the scheme and or their contract. So again, the Supreme Court is saying we're not going to interfere with that, and we don't think it's right to interfere with that. And they're, giving their support to adjudication, including in the insolvency, including as part of the insolvency process. Now, the final point will lead us into our following case. What they're saying is that the courts may not grant summary enforcement due to the insolvency process itself. That is a separate point that arrives out of the Supreme Court allowing liquidators to use adjudication in order to resolve their disputes. So the conclusion is that liquidators and administrators can resolve an insolvent company's claims through adjudication. This is helpful considering the current economic outlook, unfortunately, post-COVID-19. It reinforced the court's position that adjudication works, and only in very limited circumstances will they prevent a party from using it. So that's the position following Bresco versus Lonsdale. So what they're saying is that, yeah, liquidators can use adjudication. So that's a very simplistic view of what comes out of Bresco. I mean, like what they're saying is that there will be other considerations for liquidators to take into account. Largely being, what was agreed under the original contract between the insolvent party and the party they're seeking to get money from. Also, as well, is how does the liquidator look? Because for reasons we're going to come on to, the liquidators may have entered into arrangements with third parties that could affect the subsequent proceedings, which would mean that the court could be in a position where they would not enforce the adjudication decision. So that's the takeaway from Bresco versus Lonsdale, which leads us into the following on case of John Doyle Construction versus Erith Contractors. Now, this case came out probably about, a couple of weeks ago. I mean, it's a case that relates to a project. It was actually the paving at the Olympic Village North here in London back in 2012. The claimant was John Doyle Construction, who are now insolvent. They were the paving subcontractor on the project. The defendant was Erith Contractors Limited. They were a management contractor to BAM at the time. So a brief timeline on this is that back in 2012, John Doyle completed hard landscaping works on the Olympic Village. In 2013, then John Doyle Construction entered into liquidation. In 2016, the liquidators appointed a company called Henderson Jones to recover debts on behalf of John Doyle Construction, and the debts were assigned to Henderson Jones under that process. Then in 2018, John Doyle Construction, through their liquidators, commenced an adjudication seeking $4 million in a final account for the same project, and they were subsequently awarded $1.2 million by an adjudicator. Now, this case got caught up essentially in the with the Lonsdale versus Bresco case that we discussed earlier, because they're very similar. Like, some of the facts are very similar, and basically this case got delayed and adjourned multiple times. Whilst the courts were waiting to see how how Lonsdale versus Bresco was finally decided. Even back in June this year, the case was again adjourned pending the outcome of the Supreme Court, because obviously the Supreme Court would decide the matter in relation to whether the liquidators could use adjudication at all. So so again, it's a development of Lonsdale versus Bresco that's come very quickly after Lonsdale, but reason being is that it was actually going on in parallel, so hence the reason, the very quick development of the same area of law. So legal background. So there was the 5 elements basically that had to be decided. We can go into these now. I mean, there's the 5 issues which I discuss in the slides. So issue 1 was related to, was the dispute in relation to the whole of the parties' dealings or one single element? Now, this is a very important aspect for the court to consider, because they felt that tightly defined disputes would not be suitable, which includes smash and grab adjudications, which was confirmed at paragraph 55 of the judgment, where the judge said that the type of overly technical dispute concerned with services of notices within particular numbers of days that are called smash and grab adjudications would rarely, if ever, be susceptible to enforcement by way of summary judgment by a company in liquidation. The decision here on the facts of this case, the liquidators, the adjudication was brought on a true value or a final value basis. So it wasn't just a smash and grab, because the courts are saying if there's a party insolvent, they won't be finding in favor of the insolvent party on the basis of a very narrow technical dispute being brought by the liquidators. So on the facts here, the decision of the adjudicator is to resolve all elements of the dispute, and that was exactly what it did. In this case, as it was a final account dispute, therefore enforcement was available. So that's a warning from the court to liquidators. What they're saying is, I mean, it's one of the few warnings to liquidators. What they're saying is that, fine, you can now avail of adjudication, but on this ground, certainly, they're saying don't bring you know, very narrow, tightly defined technical disputes in front of us, because we're not going to enforce them. So they're sending a warning shot there. I mean that it's not quite, you know, open season in relation to liquidators or administrators for that matter as well. So yeah, so that was the first issue that was decided here in John Doyle and Erith. Okay, so issues 2 and 3, we kind of merged these together. So the issue was, were there mutual dealings outside the construction contract, which the adjudicator had resolved? Now, on the fact is outstanding between the parties under a separate contract at Tooley Street Fire Station for £40,000. This had also been taken into account by the adjudicator, and therefore was not an issue before the court. So you can see, I mean, Erith Construction would have raised this, saying that you know, another defence available is that John Doyle owed them money under a separate contract. Now the adjudicator had actually dealt with that point, so it was an issue before the court. But if, you know, in future proceedings, if the adjudicator has not taken that point into consideration and the monies are deemed to be significant enough, then it's something that the court may very well look into. So it's just something to bear in mind. It wasn't something, and it wasn't something that the court had to deal with here, but it may have to deal with in future proceedings. The issue 3 was, were there further defences available to Erith which had not been used in the adjudication? So the existence of this claim alone was not significant enough. This claim was being the Tooley Street Fire Station. What the court said was that the existence of that claim alone was not significant enough to defeat the application for summary judgment. If the court were to consider this as a defence, it would depend on the size and the type of the claim. So there you can see that again, the court sending a warning shot to say, if in future enforcement proceedings, the adjudicator has not dealt with defences available to the paying party, again, the court is just saying that, you know, we will deal with them if it comes before us. But obviously what it says is that it will depend on the size and type of the claim. So again, you know, what they're saying is that it has to be of reasonable substance, in order for them to, you know, to go into any great detail in the analysis of such points. So that's so move on to the next issues, which is really the crux of the claim. So issue 4 and 5. So was the liquidator prepared to offer appropriate undertakings, such as ring fencing the enforcement proceeds, a guarantee, or its after the event insurance? Now, as I said, here is a key issue, because if the court granted summary judgment to the insolvent party, would it be depriving ECL of recovering its cross-claim, which had been subsequently raised by Erith? Now, in order to satisfy the court here, the liquidators willing to ring fence the enforcement proceeds. What they were willing to offer was a letter of credit to repay the enforcement proceeds, and after the event insurance policy. Now, that after the event insurance policy is to cover legal costs, which may it's effectively an insurance policy for legal costs. So they were offering that to cover Erith's future legal costs that may be involved in them pursuing their cross claim. Now, this particular, on the facts of this case, it was complicated by the agreements entered into by the liquidator with third parties. Now, you remember earlier I said that they entered into an agreement where they assigned the debts of John Doyle Construction to a company called Henderson Jones. And the agreement with Henderson Jones was that they would take, if they would reach a settlement Henderson Jones would take the full amounts, and they would issue 45% to the liquidator. So there you can see a problem with trying to ring fence money with the liquidator, because already the party who are bringing, who have been assigned the debts are entitled to retain 55%. Therefore, that money is effectively going to evaporate. So you can see the problem with this, and ultimately the safeguards were not satisfactory to the court. The court said that a letter of credit wasn't the security that it was looking for, and it was not equal to the paying party's ability to recover sums from a solvent company. So it failed on that ground, and also said that an after the event insurance policy again is not equal to having a solvent company to pursue. And so the decision was that the security was insufficient, and the summary enforcement was refused. So again, whilst we say under Bresco versus Lonsdale, that adjudication is available to liquidators, there's a lot of other issues to take into consideration. When you're bringing your adjudication proceedings and subsequent enforcement proceedings, and the court is reminding them of this, and a very useful case here for liquidators to bear in mind, when considering adjudication as a means to resolve sums later on. So conclusion, so the courts will consider the security point on its own merits, which liquidators need to consider in their adjudication and enforcement proceedings. Of the enforcement proceedings is favourable for a claimant, but this is difficult in situations where liquidators have assigned rights to third parties. In this case, being Henderson Jones, which is a point. I mean, there was another recent case called Stiles and Wood versus GE SIF, where ring fencing was provided, and that was enforced. Again, that was based on a principle in another case of Meadowside. So, the liquidators do really need to take this this ring fencing point very seriously, because the courts are very much in favour of it. In fact, without it, you really struggle to be successful in enforcement proceedings. So the final point here is, whilst adjudication is still available to parties in liquidation, there are many other factors to be considered in order to be successful. So, so I guess the floodgates haven't opened somewhat. It's great that, that, liquidators can avail of adjudication, but the reality is that there's many other factors to be taken into consideration in order to recover the sums claimed to be owed. So that's going to conclude our insolvency and adjudication section. Some very interesting case law there. Area that continues to be to develop quite quickly, actually, and I'm sure we're going to see further further developments in the next few months, again on similar issues. But yeah, it's good stuff to to know about. If you are dealing with a solvent party, and what grounds of defence are available to you. Okay, so final point. So we're moving into the final area. This is going to deal with some formalities. Recent case of Lane and Developments versus Kingstone Civil Engineering. No. So case background here. It was a project up in Cheshire. The claimant in the enforcement proceedings was Lane and Developments, who were a main contractor. The defendant was Kingstone Civil Engineering, who were enabling work subcontractor. Now, it's an interesting case, some very interesting stuff going on here, which we'll see through the following chronology. Now, this is all based in 2020. It's all very recent stuff. So we'll start from the top and work through it, and you can identify the issues as they occur. So on the Kingstone issued their interim application 17. for the sum of 356k. Now, on the 20th of March, Kingstone sent a request to the RICS to appoint an adjudicator on the basis that Lane End had failed to issue a valid payment or pay less notice, and as such, the 356k was due. So they issued a request, and subsequent to that, on the same day, at 11 o'clock, in a meeting, they handed the notice of adjudication to Lane End. Interestingly as well, that this meeting was secretly recorded by one of the representatives of Kingstone, which is another issue that we'll deal with shortly. On the 23rd of March, the adjudicator was appointed and Kingstone issued their referral. The 24th of March, Lane End challenged jurisdiction on a failure based on Kingstone's failure to issue the notice under the scheme. On the 25th of March, the adjudicator found the notice contained a clear intention to refer, so the adjudication continued. Now, on the 8th of April at 8:39, Lane End, the adjudicator sent an email to Lane End, and received a automatic response saying that Lane End were closed due to COVID-19. So at that point, the adjudicator was wondering what to do, and at 10 o'clock that day, he sought to terminate his appointment on the basis that Lane End were, they were closed due to COVID-19. So, but basically, the adjudicator sent an email to Lane End saying that he was terminating. Unfortunately, didn't send it to Kingstone, which is a very important fact which we'll come on to. So a week later, on the 15th of April, Lane End notified Kingstone of the termination. At this point, Kingstone weren't aware that the adjudicator had effectively sought to terminate his own appointment. Later on that day, Kingstone argued the termination was void, as they hadn't been made aware of it. And also, Lane End effectively paid the adjudicator's fees at that point, seeking to make sure that the adjudication was over. The following day, the adjudicator found that Lane End were not closed due to COVID, and he sought to continue with the adjudication, and issued instructions to confirm that. On the 20th of April, Lane End issued their rejoinder, and on the 27th of April, the adjudicator issued his decision and awarded $356,000 to Kingstone. So you can see a very unusual set of facts going on in this case, which makes it quite interesting, because there's multiple issues that arise out of it, which we're now going to review. So the first issue was in relation to the appointment. So was the adjudicator validly appointed under the scheme? Now, paragraph 2.1 of the scheme confirms that the referring party must submit their request for an appointment following the giving of a notice of adjudication. So the scheme is clear that you can only request an adjudicator once you've issued the notice. That is not what Kingstone had done. So on these facts, as the request to nominate was completed prior to issuing the notice, it was ineffective, basically. Kingstone tried to argue under paragraph 1 that the notice could be given at any time, but the judge found that the scheme is clear at paragraph 3, and it requires the notice to accompany the nomination request. The outcome was that you can serve the request to nominate before the notice, and as a result, the adjudicator here was not validly appointed. So the second point was the adjudicator's termination. So had the adjudicator validly terminated his appointment? The judge found that the adjudicator's termination email was intended as a notice of resignation. Under paragraph 9.1 of the scheme, in order to be valid, the notice of resignation must be served on both parties. And here, unfortunately, the adjudicator had issued the notice of resignation to lay an end only, and therefore decided that the resignation was ineffective. So again, you know, it gets real formality points here for all parties involved here. It's not just the referring party and the responding party. A real, you know, the court is, you know, just confirming the formalities, you know, if there had been any confusion in relation to, you know, to what the scheme says and how it should be interpreted. The next issue was in relation to the secret recordings. So could Kingstone rely on a secret recording as evidence that the adjudicator had been requested before the notice was issued? So Kingstone sought to rely on this as it proved Lane End knew the adjudicator requested and were effectively almost waived their point to challenge this, to challenge the adjudicator's appointment. So questions that came were, you know, did the recording amount to unlawful interference with the European Court of Human Rights, Article 8 rights of privacy, and was this processing personal data within the meaning of GDPR Article 4.1 without complying with the regulatory requirements of GDPR and thus unlawful? Now, this was an interesting point that could have been decided, because it seems to be a trait that is becoming more common, where, you know, with the use of smartphones, etc., meetings are being are secretly recorded in case a party wants to rely on them later on. Now, it wasn't actually decided in this case. I mean, what happened was that the recording was submitted along with a witness statement shortly before the court hearing, but the judge refused to consider it as it would result in procedural unfairness, so the point was not decided. You know, so there are points that need to be considered if you're thinking of covertly recording a meeting in future, that you may be processing, you know, personal data unlawfully, or you're probably not going to be able to rely on that if you're trying to record it secretly. You know, it's a different point if everybody is aware, but unfortunately it wasn't dealt with here. But I would expect this point to prop up again soon and be closed out definitively. The final point was, had Lane End waived the defect in the adjudicator's appointment? It is a well-established principle that a person waives by election its right to establish a substantive point if they act inconsistently with the right having been presented with the choice. So the judge found that Lane End had not been presented with such a choice here. There could be no adjudication until the notice was served, and until then, no opportunity was presented to Lane End to choose between two alternative courses of action. So Lane End were never, you know, the choice was not clear to them in relation to waiving the defect in the adjudicator's appointment. So they couldn't, you know, without knowledge, effectively waive. So the judge rejected that argument that was put forward by Kingstone in the enforcement hearing. Okay, so on this case is that if the adjudicator has not been validly appointed, this defect cannot be waived by the responding party. Even if, I mean, the responding party is very rarely, if ever, going to want to waive any defect in the appointment anyway. So you'd have to start again and go back for another, but go back and do it properly. Go back and issue the notice first, and then issue the request to nominate an adjudicator. The issue of service and the importance of email addresses under the contract was key, along with other points on proofs such as read receipts. I mean, you know, the adjudicator, if he had read receipts, he would have seen, you know, I mean, he should have checked the contract anyway to see that, you know, he was writing his resignation email to the correct parties, and that they had in fact, you know, checked that. I mean, so what he's saying is that adjudicators need to be alive to that point to make sure that the resignation is valid. The third point is that by challenging jurisdiction based on an invalid appointment, this can cover a number of different points later on. So, it can go in as it's somewhat between a general and a specific reservation, but in these circumstances, it actually covered various points based on the unusual facts, present in this case. Finally, it's just a reminder to get the formalities right. Get the scheme. Have a look at the scheme if you wish to refer. Pick up. Get the right advice, because it can delay the process unnecessarily. You can end up going to enforcement, spending a lot of money on fees, only to find that the formalities weren't complied with. So it's very important to get the formalities right in these situations, and they're clear for everyone. So the courts, if the formalities aren't correct, the courts are, they're not going to be granting enforcement. So yeah, get the right advice. Pick up the phone. We're always available here. If you have any queries in relation to how the scheme should be interpreted. Okay, that's it, guys. That's it for today. So we covered points in relation to true value. Remember, you got to pay the sum stated as due in order to go back for your true value position, or even subsequent litigation proceedings. So that's where the courts are at based on the earlier case law. The insolvency point. So liquidators can resolve disputes through adjudication, but there are a lot more issues to take into consideration. Security for funds being paid to parties who are insolvent, as we looked at in the case of John Doyle versus Erith. And finally, just a reminder, if it were needed, to get the formalities right. We saw the importance of it in Lane End and Kingstone, which ended up costing a lot of money and a lot of wasted time without any successful outcome. So just a final reminder to get those right, if it were needed. So yeah, look, that's it for me. That's the conclusion. Look, I'm happy to take any questions now that you may have. Thank you all for joining me, and yeah, look forward to seeing you all soon. Thank you.
Thanks, Conor. We do have a question that's come in. Are consultants' fees that come under the provisions of the scheme recoverable via adjudication?
Consultants' fees which come under it. Yeah, it depends on. It depends on the scope of the services being provided. In a consultancy agreement, a lot of consultancy agreements I've seen do confirm that that fees can be referred to adjudication. So largely it will be available under the terms of the consultancy contract itself. If they're construction services, then largely they should be recoverable through adjudication. So it's a very narrow point. If you I see it's Nigel Moran has asked the question. It can be, it's very specific. So if you do wish to get the point answered definitively, please send me an email. I'll have a look at it and just try and point you in the right direction, free of charge as well. So that's yeah, I look happy to consider it, but it's very much dependent on what the wording of the the consultancy agreement in fact is, and what the services are as well. Okay.
Well, there you go. Words you don't often hear from a lawyer, free of charge, and it's on video. I'm sure someone will hold you to that, Conor. Okay, that seems to be the only question we've had so far, so that's great. Well done. You've obviously explained it really well. In the meantime, hopefully we'll see some of the people online. We'll see you again at 6 o'clock tonight with John Sharp for JCT Constructing Excellence, or Will It Catch On? Otherwise, hopefully we'll see you again next Wednesday for more information. So, Conor, thank you very much. Everyone else, thank you for joining us. Hope everyone has a good day and that the rain has ceased wherever you all are. And we will see you again soon. Thank you.
Thanks, everyone. Thanks.